I mean, I just don't think that that's the right way to do law in some sense. I don't think law is a subfield of linguistics, which is sort of what I think a lot of people are starting to try and treat it as. Like the idea is that a legal question is dependent upon a linguistic question. And I don't think that's always the case.
Hello, and welcome back to Tomato Tomato. I am your host, Talia Sherman, and welcome to part 2 of my conversation with Alex Walker, the current Rappaport Fellow at Harvard Law School, a lecturer in law there, and a fellow in law and applied neuroscience at the Center for Law, Brain and Behavior. As promised before, this episode is going to use linguistic theory to make claims about legal frameworks, about political philosophy, about our practice of law and our relationship to law. And in part 1, we talked about how an understanding of language and linguistics is highly beneficial when actually running the legal system and practicing law. In this episode, I think that law ends up being completely divorced from linguistics and questions of language. And that's really cool for a number of reasons, not least of which is that this episode is entirely about applying a linguistic method and theory to law. And yet, by the end of this episode, I don't think this has anything to do with language at all. I think this has everything to do with what we talked about at the beginning: politics, policy, jurisprudence, political theory. And we wouldn't have divorced language from law, or questions about meaning from law, if it weren't for the linguistic theory that Alex proposes we apply to law. And that is really cool. I want to say here as well that I learned a ridiculous amount from Alex throughout the process of interviewing him, editing, recording, and producing these episodes. I hope they're educational and influential for all of you out there. But without further ado, please welcome back into your ears, Alex Walker. You said to me in an email that you're working on how to apply optimality theory to law, which is like so cool. But then also just these broader theoretical connections between linguistics and between law. How do we apply linguistic theories and methods salutarily to legal systems, to law scholarship?
Yeah, so there's sort of two things going on here, right? And so the one is, right, I think that a lot of sort of that philosophy of language stuff that you were talking about before is sort of trying to say, okay, what does this word mean? Like that's basically what that's their project, basically. And like in short, what does this word mean? There's this famous example. There's a law that says no vehicles in the park, right? Does this apply to a stroller? Does this apply to an ambulance? Right?
Yeah.
Does this apply to, right? So that this is like sort of this great hypothetical that is given to first year law students all the time. And the question is, what does vehicle mean? Right? What does it mean in the context of the statute, right? And so the philosophy of language people are going at it. And they're saying, okay, we could do an empirical study and ask people sort of, does this apply? I read a paper that came out in February that said, let's ask ChatGPT what a vehicle is and see what it says. There's other people who say, well, okay, what we should do is we should do corpus linguistics. We should go back when the statute was passed and look at the corpus and say, how do people use vehicle, right? And then there's other people that say, well, no, corpus linguistics doesn't make sense because really what we need to include is the idea that people will have deference to certain actors, right? So maybe you think, well, people didn't know that ice was water at some point, but then we have this practice of relying on what scientists say. And so everyone was wrong about what water meant. And then the science came in and said, and so that means that water really did include ice the whole time, but we just didn't know, right? So there's all these different theories of meaning and that sort of thing. And I think personally, maybe I'll change my mind at some point, but I think a lot of that is red herring. I think the idea that we need to be applying like sort of like these really hard like linguistic tools to come to sort of the correct meaning of a term when we're thinking about a law is not necessarily the right way to think about it.
Can I just add like one more example of something that like maybe people will know? Okay, so back, I don't know, I mean like I certainly wasn't alive, but like, okay, Bill Clinton, master legal mind, when asked about a sexual relationship between him and Monica Lewinsky, sort of obfuscated this to no end by saying, well, I didn't lie because it depends on what the meaning of the word is. Is there a sexual relationship between you and Monica? Well, does is mean that there is currently one or that there has ever been one? So if you were telling me that there is not currently one because there was not at the time of the hearing, literally then, or in like a reasonable time frame, asexual. Had there been one in the past? Yes. But he can argue that. So that's another place where just one person was able to be a little linguist in one moment, even though he didn't study linguistics, as far as I know. So yes, continue.
Yeah. So there's all these sorts of debates about, what meaning is, what do words mean, what does is mean. There's this Supreme Court case. I don't think they've come down with it yet, where there's a debate about what the word and means in the statute. Yes,
What?
literally.
It's the union of
There was a
sex. Okay. But didn't you take semantics? No, no.
Yeah, there was another case where the question was whether bees are fish, I think, in
No.
California. Yes, I
Ah,
think the California Supreme Court ruled that bees are fish in the context of, yeah. Yeah, so there's all sorts of fun, like, linguistics adjacent problems. But I think I just don't think that that's the right way to do law in some sense, right? So, like, I think, I don't think law is a subfield of linguistics, which is sort of what I think a lot of people are starting to try and treat it as. Like, the idea is that a legal question is dependent upon a linguistic question, and I don't think that's always the case. That's a different discussion. But the other thing I think we usually do in law is we describe things as rules, right? We say there is this rule, and what the judge is doing is the judge is applying this rule, right? And that is, usually how we also describe phonological processes in a language in your first year phonology class. We say, when you have a voiced stop at the end of a word in German, it gets devos, right? And we say that we describe that as a rule, right? And that's sort of I think the current paradigm for how we describe legal rules. And that's how we do it all the time. The judges say what they're doing is applying legal rules. But there's also a sense to which, people will have all these disagreements about the edge cases of the rule and the law and what it means to apply a standard and all these other things. But I think with the interesting insight from optimality theory.
can you explain like a little bit of like.
Sure.
I mean, I found a video that I probably link in the episode description that basically explains optimality theory, but
Sure,
using an example of like going to a party. So basically it's like two people want to go to a party. Jane has a rule. I can't go to parties. So then, or like I'm asleep by 9 or whatever. So like that's the rule. And then Kate has the order of preferences, and like one of them is sleep, the highest one is sleep, and the next one, blah, blah, blah. And because the party violates the highest preference, no party. Great.
Right. So I guess the way to describe optimality theory in the context of linguistics is, and the place it was first imagined, I believe, was in phonetics and phonology, was how do we describe sort of phonological rules that occur in any given language. So, the past tense of the verb in English is a common example. We think there's an underlying form D, and we think that, okay, if there's a T or a D, then we pronounce it ud. And if there's, an unvoiced consonant besides a T, we pronounce it as just a T sound. And anywhere else, we pronounce it as a D, right? And that's sort of the way that you normally describe like the phonological rule in linguistics. And phonology has sort of this formalism that you can write down as a sort of like literally like a formula, like this formula that you write down, you show the environment, the underlying form, and then what that transforms the sound into, right? So that's the normal way we describe sort of phonological rules in linguistics. And then optimality theory comes along and they say, well, what if we didn't describe it as sort of this transformation of an underlying form, but instead we said there's the underlying form, and then we said that there were candidates that we could pronounce, so possibilities of how to pronounce it, and then we basically optimize for something on those candidates, and then pick the candidates that optimizes best, that does the best job. And usually the way they describe that underlying optimization is the set of ordered preferences. So ordered preferences that describe sort of the past tense rule in English would be something like keep harmony of voicing of consonants together, avoid sequences of like sounds that are too similar to each other, don't add things, don't change things, and avoid consonant clusters, right? And so you can have sort of this set of ordered preferences, and then you choose the candidate that satisfies those preferences best, and that's what ends up being pronounced. And you can use that to predict exactly the same thing that you would given the rule. And some of the benefits that people say that optimality theory gives is that, okay, maybe if we have a rule, it sort of only applies to that situation, but these ordered preferences might be more general. So, for example, that same set of ordered preferences that you can use to describe the past tense in English can also describe the present, the third person singular, and the verbs and possessives and all sorts of other phenomena in English which might have us being able to say something like English as a whole has this ordered preference set, and this ordered preference set is general, and we just apply it wherever something is going to be pronounced.
Right. So I think a key part of this is that it may not actually lead to a different utterance or like realization
precisely.
of a phoneme. Right. So like, for example, in English, we have like the underlying like plural is like z, but sometimes it's s,
Right.
voiceless. So like if we come to an end of a word, for example, dogs, cats, right? It could be that it's cat,
z. And maybe the rule is just it's a T and it's voiceless, so therefore it is voiceless as well. But optimality theory gets us this order of preferences. So like the highest order preference might be something about, again, like harmony of voicing or things like that.
Right.
And then we understand a little bit more about why we got to the
Exactly.
same realized phoneme.
Exactly. It sort of gives you a reason for why the rule is there. And it also helps you compare languages too. So for example, like in Spanish, right, at the beginning of a word, we don't like SPs. We don't like, right? And so we add an E to the beginning, right? So not spinal, but espinal, right? So like you do these certain things. You can describe that as saying, okay, maybe Spanish has this rule, or you could say it's doing the same thing as English, really, but the ordered preferences are switched. So right, so like the where we prefer consonant clusters has been changed, right? This is why this is sort of also a theory of UG, of universal grammar, excuse me, where they're saying that there's this universal, this is like the maximal optimality theorists would say this, right? I'm not saying all optimality theorists would say this necessarily. The maximal way of putting this is there's one giant set of ordered preferences that all humans' languages have, right? No matter where or who is speaking them. And all the languages are doing is having different orders in the preferences. And that's what causes all the differences between languages, would be the maximal way of putting optimality theory.
Yeah. Okay. So going into law, I am very interested as to how this applies, because from what I've read so far of your stuff, it seems to me like you're arguing that this is not necessarily a good or bad thing for linguistics, but just like not even necessarily at all suited. It's more suited for law.
That's I don't know if I put it so strongly. I mean, I'm sort of remaining agnostic with respect to optimality theory in linguistics, but there are sort of the two main problems, I guess you could say. The two main criticisms that people levy against optimality theory in linguistics don't really apply to law. So let's take those one by one. So the first one is, so we said the rule, right? The rule is there's a T, therefore the Z turns to an S. Fine. Optimality theory has to say something like, if you're saying this is a neuropsychological theory, our brain generates both the cat s and the cat z versions and then compares them, right? And then exactly how, and in theory, right, there could be an infinite number of ways to pronounce any given underlying set, right? Why S to a Z? Why not S to a sh? Why not S to a yada, 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 yada? And so because of that, you have to sort of come up with some sort of theory, if you're saying this is a neuropsychological theory, of the actual linguistic mechanism in the brain, of how you come up with the candidates for the possible ways to pronounce things, right? There's not like necessarily a closed set of choosing what should be the candidates. In law, this isn't really a problem. So for example, if here's an example I use in my paper, if you and I were married and we decide to get divorced or annulled, right? The court sort of has three options. Either they can say we're still married, we're divorced, or the marriage has been annulled, right? The options present themselves. We can't be half married. We can't be, right? So there's sort of there's a discrete set of possibilities that occur in any given case. And so that means that sort of this problem of the candidate set isn't really a problem. And the second problem is that if we think that there's rules being applied, sometimes they'll happen sequentially. So you might have one rule that triggers an environment that triggers another rule, right? And humans aren't perfect and we make mistakes all the time. And so in theory, you might expect, well, maybe someone would forget to apply the second rule. So sometimes if there really is neuropsychologically a rule being applied, we might see an intermediate form that's only the first rule being applied and not the second rule. In optimality theory, you don't have access to these intermediate forms because you're just choosing the candidate that satisfies these ordered preferences best. There's no sequential application of rules. And because we do see these intermediate forms, optimality theory, if it's trying to not be some abstract thing, but actually a theory of, like a scientific theory of the neuropsychological and linguistic mechanism, we would have to have a reason why we see these intermediate forms that don't seem to jive with the ordered preference set. And again, in law, we can't be half married, right? There's no way to observe an intermediate form. And so because of that, sort of what my idea is here is to say, what if we took some normal legal rules that are usually described as rules, right? And what if we said, instead, what the law is this ordered preference set and not this set of rules? And I think that has some interesting consequences and can be a useful mechanism for describing the law, describing legal change, and also describing sort of the way we should think about different things like interpretation and differences between legal systems, right? Comparison between legal systems.
Right. Okay. So let's like go into a couple of these examples because I think
Sure.
it's important to like think about like how this affects all things. Because for me, what I'm thinking is like, okay, if this idea makes it big, which, you know, there's no telling that it won't, does it
You put that out in the universe. Thanks.
Sure. I mean, it transforms, number one, like how we, like the pedagogy of law school, like how we're like training
Yes.
lawyers, things like that. But then does it like infiltrate all the way into our, you know, somewhat codified legal system? I mean, more codified than most, common law, whatever.
Not all states. And this is actually an example where this is a technical example where I think that this was not in the draft that you read. But okay, so this is going to get really technical law for a second, but I think it's worth it. Okay. There's this case called Erie Railroad v. Tompkins. Okay. And it is often called the most important case that non-lawyers have never heard of, right? So the idea is this. Sometimes federal courts can hear cases that don't have to do with federal law. Okay. So there's this thing. So federal courts have diversity jurisdiction. And basically what this means is, say you and I are in, you know, Rhode Island or Massachusetts, and there's a normal dispute between us about negligence or something, right? If we're citizens of different states, right? And the amount in controversy is above a certain amount, usually $75,000, then we are able to sue in federal court rather than state court, even though it's about the common law, as you said, like it's a common law thing, which has to do with state law, usually, not federal law. But we can sue in federal court, and the idea is, look, if we have citizens of different states and we go to state court, you know, if we go to Massachusetts, right, and I'm a Massachusetts citizen and you're not, maybe the Massachusetts court would be biased against me, right, and vice versa. So we're saying, okay, maybe we want a federal forum to resolve these certain types of cases, right? And so prior to Erie, the case Erie, the federal courts would do basically whatever they wanted in the case. They wouldn't do what the state courts did. They would just come up with their own way of resolving the case. And Erie said, don't do that. Do what the state says. Follow what the state says to do in this case, right? So, right. And so there was the idea that there was a lot of forum shopping going on. So basically it's like, okay, if I know that the federal court would decide with me, I would go to federal court instead of state court, right? And so people were choosing between the federal and state courts because they weren't matching each other, right? And so Erie said, stop that, right? And they said, basically, the reason we should do this, they said the federal court needs to follow the state law on the issue. But have you heard of Louisiana as a state? The state of Louisiana, right?
Yes.
They're not a common law state.
Okay.
So they're a civil law state. And what they say is, actually, our court cases are not authoritative on the law. The Louisiana Supreme Court says our court cases are not authoritative on state law. So then the question is, does a federal court in Louisiana need to follow what the Louisiana Supreme Court says?
Got you. Yeah.
Right. And so you have this weird contradiction. And so if you think that the law is this rule that they need to follow with what the highest court of the state says, then you have this contradiction. If you say really what the law is a preference against forum shopping, you don't have the problem. Because you just say, well, what would solve the forum shopping? Following what they say, regardless of what the rule is in Louisiana, right? The common law sort of got me there, right? So certain states, right, Louisiana and, well, not a state, but a territory, Puerto Rico, neither of them are technically common law states. They follow the civil law, where the court cases aren't technically the law of the land. The code is the law of the land. And that's not for all issues. It's a little more complicated than that, but that's the basic idea, right? And so that's one area where I think this sort of framework actually does help us solve some problems, right? And I know that was a technical and drawn out example, but that's one of them.
No, that's a great example. I think that's a beautiful way to illustrate, though. The Supreme Court in Louisiana then is like kind of some sort of higher order preference that's then like contradicting itself, which is kind of interesting.
Well, it's not contradicting itself. It only becomes an issue when the federal court has to say what we're going to do. Because Louisiana Supreme Court can just say, look, we don't follow. So basically, they don't. Have you heard of stare decisis or the idea of precedent?
Yeah.
Right. Basically, Louisiana rejects the idea of precedent. They say we don't have precedent in Louisiana. But the federal court is saying we must follow state precedent. And Louisiana is saying we don't have that.
Okay.
Right. And that's where and so if you think that the idea is the rule, right? Federal courts follow state precedent.
Yeah.
And you think that's the rule, it makes no sense in Louisiana or Puerto Rico. Right. But if you think actually Erie, this case, didn't instantiate a rule. It instantiated a preference against this particular type of forum shopping. Then you get how you should resolve the case. right?
Yeah.
And there's ways of getting out of it with the rule, but you have to add more rules. You basically say something like, if they don't have the doctrine of precedent, follow it anyway. But that's an additional rule that people don't usually consider Erie as having said. You have to add something to it, right? So that's where that's why I think the ordered preferences is useful. And basically, in the ordered preference set, all you say is before Erie happened, right? You had horizontal uniformity. So if you went to a federal court anywhere in the country, they would do the same thing basically, right? Because they had their own system. But now you have the opposite because the federal court sitting in Georgia has to do what Georgia does, and the federal court sitting in New York has to do what New York does. You no longer have horizontal uniformity. So basically, all Erie did was switch the type of uniformity you had. And so you could think of that as a switch in the ordered preferences. So before we had this preference for this type of form shopping over that type of form shopping, and all Erie did was switch them. And that sort of makes it less inscrutable as to sort of like, what is this new rule about, precedent and all of that other sort of stuff. So that's one way of describing the new way this rule happens.
Okay. Still wanting to go for it. So you talk a bit in the draft about how like sometimes with the rules, we just like we don't strike down laws. We just like stop them from being enforced, right? Abortion is a good example. Yeah.
Yeah. So this is maybe something that non-lawyers often don't understand. So for example, this is happening right now with abortion.
Yeah.
Right. So Roe v. Wade basically said it's unconstitutional to have certain laws that are too restrictive of abortion, right? So just to make it as broad as possible so we don't need to get into the details.
Yeah.
Right. It said something like that. And so let's say a state or the federal government had a law, right, on the books that did violate Roe v. Wade, right? What Roe v. Wade did was not say this law is no longer on the books. It just means that if anyone tried to enforce this law, they could get an injunction from a court saying, don't enforce that against me, right? It doesn't mean that all those laws are repealed.
Yeah.
Right? And that means when Roe v. Wade fell, right, you get an Arizona law from the 1800s that's still technically on the books and can start being enforced. And if you're in a rule-based framework and you're trying to describe the law and Roe v. Wade is still the law, you would say something like, the rule says this about abortion, right? But that doesn't help you explain that when that rule goes away, why there's other things start cropping up, right? But the preferences approach says, no, those other preferences are just being suppressed, right, by this higher ordered preference. And when you remove that higher ordered preference, all these other things start coming to the fore. And that sort of helps. And that's why I use the analogy of a tapestry, right? If you have something on the front, right? But if you start removing fibers, there's different fibers below it. Just because you put something on top of something else, it doesn't mean that stuff below went away, right? We have object permanence. And so you have these sort of underlying preferences, right, that are below the higher order thing that you just don't see expressed. And that's sort of the same thing that optimality theory is saying in linguistics. You're saying like, look, maybe if we only see, right, the T in this particular form, that doesn't mean that there's not these other things below it that are just being suppressed by this higher order preference in this particular example.
Right.
Right. And now in that particular case, right, I don't like that.
Yeah.
Right. There's plenty of reasons why I don't like that.
Yeah.
But this explains why that's the case. And it helps us when designing a rule of law or the law to make sure that we are aware of that when we're designing our system, right? Because if we just think this is the current rule, right? If you just told someone, right, in 2018, this is the rule in the United States, this Roe v. Wade is the law, right? That doesn't tell them what happens when Roe v. Wade comes away, because you're just giving them the rule, right? The current rule in effect. But if you were to give them the tapestry and to say, here are the ordered preferences of the United States, they would immediately say, oh, if Roe v. Wade went away, this is what would happen. And so that helps sort of explain, and depending on your particular political project, maybe galvanize some sort of movement to make sure that we have the entire tapestry we like, and not just whatever's currently the highest order preference, right? So it's sort of, I'm saying the law is when you're discussing the law, you need to discuss the whole tapestry, not just the highest order preference that is at any given day, because those change over and over and over and over again. They change a lot, right?
Right. Yeah. And it also makes it a little bit, maybe not necessarily the whole truth to really say when people would say like, oh, well, if Roe gets overturned, it's just up to the states. Well, the state in what era, right?
Right.
Yeah.
Exactly. because and this is sort of related to, I guess, like social choice theory. It's like, okay, it's sort of like default options. The default option can be very powerful. And so depending on whatever the default option is in whichever state, that could change things a lot, right? And I think, to be clear, I think they now have repealed the Arizona law in particular, I think.
But Texas, I
But yes,
mean, yeah.
no. But other states are
Yeah.
passing active laws. I'm just saying that the Arizona one in particular, I think that one, and now I think it's going to like a statewide referendum, I think. But yes, it's important to recognize the default options because the tapestry is telling you exactly what those default options will be when you get rid of that highest order preference.
Okay. And so when and if this theory takes over everything from the law school classroom to the courtroom, so it's going to like transform the way that like certainly the everyday citizen probably maybe thinks about a law or like how lawyers generally conceptualize law. How is this going to change though, like a judge sitting in a courtroom having to make a decision on anything, right? This doesn't from SCOTUS like all the way down, like just like what is the goal and the utility of that?
Yeah, so several things. So I think the first thing is I would hope that academics at least would think and start thinking about how they could describe things with that framework, right? And it's often the case, like for many things, right? Even in linguistics, it's often sometimes more felicitous. It's easier to sometimes to describe something as a rule, right? And that can be the case either way, right? If I say, like, for instance, I think like a statute of limitations, right? It says you have 30 days to file this. That can be described as a set of ordered preferences, right? You can do it. But it might just be easier to say the rule, right? In any particular context. So what my point is more theoretical than necessarily practical in that particular case. I think in some cases, right? I think by going down to the theoretical and then coming back up, you do get certain things. For example, if we really think that the law is a set of ordered preferences and not a set of rules, this helps you with interpretation. A statute, right, then doesn't become the law in some strong sense. And so, for example, say the statute has a clear typo in it. Should the judge follow what the typo says or what they think they meant? Right? This is called a scrivener's error, and it's a big area of debate in the law. Right? Someone might say, well, the statute with the typo is what passed through, right, the process that makes something become the law. But if you think of the law as this statute is evidence of Congress's ordered preferences in this sense, you might be violating Congress's ordered preferences by following the typo, if you have good evidence for it, right? And this is an argument that's been made before, right? But I think if you understand the law not as a set of rules and as a set of ordered preferences, it helps you solve these sorts of problems, right? And so like some judges might be trepidatious, might be like, well, I don't know if I can just override this typo, if I really think it's a typo, right? Because I'm afraid of violating the law. And I'm saying, well, if the law is not the rule, it's not follow state court precedent, it is preference against forum shopping, then it helps you solve these sorts of problems that do have actual effects. So when you're making a ruling, it reveals the preferences that you actually have underneath it, right? It doesn't just say, this is the rule. It says, here's the order preferences you're instantiating. And so that sort of gives you the tools to critique any theory, right? Because it says, okay, well, I disagree with that order of preferences. And so instead of someone saying, being able to like retreat into, I'm just following the rules, right? They have to say, this is the set of preferences that I'm instantiating. And that ranks this above this. And then you need to justify why you're doing that. And that, I think, enriches not just the debate between lawyers, but also the debate, sort of like political debate, right? And the idea that like, look, how do we want to rank our preferences as a nation? You can't just say, I'm following the rule, right? And end it there. You need to say, this is what the rule instantiates. This is what the law is. And we need to have it actually debate, like a constitutional, right? A national debate about how we order our preferences, right? And that's sort of how I imagine this being used, is to say like, no, like we should not just retreat into the rule is the rule is the rule. And the other consequence, I think, of this, which was definitely not in the draft you were thinking about, is with respect to robot judges, right? Because if you think the law is a set of rules, right, to be applied, and you don't think humans are special, like there's no soul or something like that, you should use a robot, because that would apply the rule better than humans. And we have lots and lots of empirical evidence that shows that judges basically are bad at following rules, right? That's the way you can put it, right? But if you say something like, well, what we care about is a set of ordered preferences, And part of what being a judge is meaning their preferences matter in some sense. Then to put a robot judge there in many contexts would mean to say that I care about the AI's preferences, which is a weird thing to say, right? You could, right? You can care about the robot's preferences, but it might make sense that say, no, actually, if what I'm not caring about is the rule to be applied, I'm caring about the preferences, then I care about humans' preferences. And a judge, being a human that has grown up in the society with us, is the type of preferences we care about, right? And maybe that says something about the type of judge we should choose, right? Because it says something like, okay, we want these are types of people whose preferences we care about. And in effect, that's what we already have. But it gets rid of this, I think, some of the tension between, if you really think rule of law is a law of rules, right? Why you should want a human judge. But that's sort of another consequence that I think. And it would tell you sort of when you do want a human judge and when you want a robot judge. Because maybe you do want a robot judge in some contexts, right? It'd be when you don't care about the human's preferences.
Humans' preferences, and we're like, yeah, critical thinking. It depends on if you believe that robots like critically think, but you know.
Well, it's because, once again, right? If the job of the judge isn't to critically think and just apply the rule,
Yeah.
exactly. Critical thinking is to say that we want the judge's preferences, right? The judge's criticism of whatever they're thinking about
Yeah.
to matter. But if you're saying like, no, the rule is the rule is the rule, and Erie says follow state court precedent, right? And that's what they need to do, then you would want something that follows that rule the best possible. And that sort of, I think, leads to the conclusion that you should want an AI judge. And not because the AI judge can critically think or anything like that, but something like, hey, humans are just bad at following rules. And if you want rules, you should use a computer. And I think right now, a lot of the debate, especially amongst lawyers who aren't like computer literate in some sense or don't really understand how the AIs work, is something like, well, the AI can never be better than the human, right? In this particular way. And it's like, well, you could always design an AI, right? In theory, with enough computing power that would get the outcome, right? If all you care about is just the outcome, how the rules apply, you can make the AI do it, right? And so that's sort of something, and I hope to like sort of enrich that debate a little bit with respect to that. That's sort of another thing that I'm thinking about.
Yes, right. I mean, as we've been talking about, like understanding why the teleology exists.
Exactly.
Not necessarily that the teleology exists.
Exactly.
Is really cool to think about. I know that you have done work at the law and neuroscience lab situation. So does this at all go into like anything to do with that? Are you like at all thinking about like this and neuro?
Especially with related to some of the AI stuff, yes. Yeah. Because I think, like, regardless about my beliefs or anyone's beliefs about like what it means to be human or that sort of thing, right? A lot of the time when we're thinking about sort of how to use AI and the best times to, because it is a tool, right? The best how to implement AI in the law and how to think about it. Imagining humans as a type of AI can be useful in that, right? And sort of understanding like what a neural network, which is sort of, it's mimicking like how humans learn at a very, very small scale. And that sort of framework helped me think about sort of what it means to use an AI as a judge, right? And what it means to use a human as a judge, right? Because it's to use a human as a judge is to say, we're going to now reify all the weights and biases that they had throughout their life, right? That's one way of viewing it, right? It's like, look, they were a human, now we're not tabula rasa, right? But their genetics and their environment, right, came together to form some sort of neural net that makes decisions, right? And is biased in all sorts of ways. And that is what we're using to make decisions. Or you can use an AI that we've created now, trained it on, has different weights and biases, and that's what you can use to make a decision. And so really the thing to compare is not human versus AI, but the different training environments that the two AIs went through, right? And again, if part of what I'm doing is trying to make the case for humans, I should use the least amount of presumptions in favor of humans possible, right? And so that's sort of part of what this is in some sense, right? And again, I wouldn't consider myself, against AI judges in all contexts, right? But I think sort of in order to be against them in any context, one needs a robust understanding of, one, what AI are, and two, what humans are and how human decision-making works. So that's sort of part of where that sort of neuroscience background is coming into it.
Yeah, this is fascinating. And
it's super way in the clouds a little bit, right? Compared to
Not
other words.
necessarily,
But,
though. I mean, I think like some of the arguments, especially about like the intermediate steps, like that's very compelling. Married, divorced, annulled, right?
right.
Linguistics is a billion things. And I think also like in terms of, you said at one point, like, linguistics loves rules too. Well, yeah, like maybe in all subfields of linguistics, optimality theory could even be more used. I'm thinking of like rules, not necessarily rules. Well, no, not rules, really axioms in socio, like, young women lead linguistic change, or like, there's like different like the diffusion models, like, change from above and change from below, like certain Lebovian like techniques.
And what I think that's also relevant to is because there's also this sort of like thing where it's like sort of we think of language or the linguistic mechanism it happening at the organism level.
Yeah.
Right? Like, so it's a human that instantiates language, right? The human has a brain, and the language is in the brain in some sense, right? Where it is sort of in linguistics, we sort of do recognize that this is sort of like an intersubjective thing that's going on, right? But it becomes possible and more coherent to talk about like system level preferences, right? In a way that's useful, right? So when you're talking about the socio thing, you're sort of saying like, oh, instead of just saying like, this is the rule, you could say like, well, the system as a whole has these preferences. And law in a similar way, right? It's sort of a social choice, right? It's a social choice amongst this entire giant thing, right? You could talk about it at the system level coherently in a way that's better than just like one of the examples I use is like, you can say nature abhors a vacuum. And that's coherent in a way, right? To talk about the laws of physics or the laws of whatever, right? As sort of these sets of preferences, but to talk about things as preferences at the superorganism level, I think can be useful and is often difficult to do in a formal way, right?
Yeah, I really like that. I don't know, because I think like because then you start to train like everyone, regardless of like anywhere, like to think about the why, the reality versus like that,
Exactly.
like I'm thinking of like so many examples, like variation is a feature, not a bug, like so many like little sayings that we have, and you just like learn them and you're like, oh, that's, and then you think about it and you're like, yeah, that's so true, but like why,
Right.
like why is that, right? Like there's even certain things that I think like in 5-10 years, I think like will become rules about like certain, like, I don't know, like Wolfram studies about like African American English, and like doing like lexical density studies and like looking at that and like how it dips when they enter the education system and then rises again, right? Like that's probably going to become some type of rule, because the education system has a really powerful effect on like how the density of like certain like stigmatized words or phrases or whatever, but we don't know why.
Right.
Until we get to like some sort of like order preference idea. Or like thinking about like why variation is so prominent, and like, well, the system, the society creates the environment for it to be so. So
yeah.
Yes, this is where I'm like, I want to know so many things, but I'll start with, what is your favorite linguistics fact?
Favorite linguistics fact. I think it is that babies will cry based on the phonology of the language that they heard in the womb. So the fact that like babies that hear tonal languages will like sort of cry in tones a bit, I love that. I think that's amazing.
I didn't know that. That's crazy. So do we know this from psycholinguistic like work, or?
So what they did was, so the particular study I'm thinking of is they took basically German babies and Chinese babies and then listened to their cries, right? And you hear more tone modulation in the Chinese baby cries.
That's crazy.
They will like cry based on the fact that like, yes, I think that's amazing, right? It's this idea that like language really is, really, really deep, right? Or, and I think maybe a tangent fact that I also think is related to this is the fact that baby, like that deaf babies babble, right? I sort of love that. I'm like, there's something really in there about it. I don't know if I go all the way with Chomsky, that it's like there is this brain region that does all of this, but like there's a sense that like I do, there's something that's deep in us with language.
Yeah, no, well, of course there's something that's deep. I mean, like that, I feel like that's not too much of a controversial statement to make. I feel like that's
I don't think that's
established.
But...
Yeah, so I also would love to know, why linguistics? Why language?
Yeah, no, I think it was like when I first went to college, I had no idea what linguistics was, right? I knew a couple languages by then, just by happenstance.
You know many.
Of,
wait,
random families.
No. Your CV is so impressive. Please tell people. You know many. You know many, 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 many languages. Please.
So we got English, Spanish, growing up with, and then Mandarin, and then French and Japanese in high school. And then at Columbia, sort of the department was really into sort of like Slavic. So, got some Russian, I got some, and then, self-respected linguist, I had to do some Latin and Greek, some Sanskrit on the side. I can keep going, but like, it's sort of when you ask like linguists how many languages they speak, it's sort of like they just say 72, and then you just sort of,
But you're fluent in Esperanto. Didn't you say that?
Yeah, Esperanto is fun. I like it. And it was really funny because last week one of my friends is doing like an fMRI study in the language lab about legal interpretations. They were giving me contracts, and I had to like read the contracts while in an fMRI for 2 hours. And then at the end, they were like, "Please list in order of proficiency any language you have, no matter how rudimentary." I was like, "Really? Like you want me to list like 20 languages?" And they were like, "Yeah, even if you've like only done a little bit of it." I'm like, "Oh my God!" So I'm sitting there for like a long time trying to answer all these questions about the language. But yes, lots of languages. But I didn't know anything about like sort of this inner structure of language, right? And so when I saw Professor John McWhorter at a booth
That's crazy that he's just like there talking to undergrads.
He was just sitting there at a booth, and I was like, "What's linguistics?" I was like, "Is that just like learning languages?" He was like, "No." And I was like, "What is it?" He was like, "Come to class and I'll tell you." And I was like, "Okay." And so I went to class, and it was amazing. Like I was like, "This is crazy." And so then I did like some independent research on like the typology of Ainu, which is an indigenous language in Japan. Also trying to connect with some of my like indigenous roots, and like trying to like think about like, some of those things, and like maybe learning some of those languages, maybe trying to help with some revitalization efforts. Yeah. And I just found the fact that like there was something that I knew that I couldn't express, right? Like the idea that like, someone speaks with the order of adjectives in English perfectly, right? But then when you ask them how to do it, they can't express it. It's like your heart beating. It's like you can like your heart beats and it works, but you don't make it beat. You don't tell it to beat. And there was just something so fascinating about that, right? And it just sucked me in, right? And so now I'll like wake up, in the middle of the night, and then look at my phone, and then it's like it's on like how the verbs work in Navajo or something, and I'm like, oh, it's just something of and like now studying for the bar exam, the way I de-stress myself was by learning Hawaiian.
Wow.
So like there's it's just that's just the type of person I am, but I just love it in a way, and just like the inner structure and the way that different languages express different things. That was a long answer, but
Yeah. No, I mean, I don't know how much this matters, but like Columbia is not necessarily like, well, it does not have a linguistics department yet. It's probably getting there, but like
it's getting there.
It's getting there. Like you were there at a time when linguistics was like fighting its way back, because for context and for history, let's just say Columbia used to be the linguistics place. Now way back in the 80s, before then.
Way back,
the place. And then there was some infighting, the department fell apart, it was gone for decades, and now it's fighting its way back. And it's coming back.
Yeah,
it is coming back. It is coming back.
Yeah, I think the linguistics department while I was there was technically like a subpart of Slavic.
Yeah.
So something like that.
Clearly you've done work like outside your like structured like undergraduate courses, but
right. I proposed that. It was of necessity as a faux linguistics major at Columbia to do those things, because there's only so much that the institution is willing to support you with. But that's at the time. I'm sure it's better now when they have the major. But do things outside of you run a whole podcast, so you're definitely doing it. But that's the sort of thing, interact with people in the field, and and we need young blood, so to speak.
We do, yes. Yeah. I would like to think that I am. Thank you so much for listening to Tomato. I have been your host, Talia Sherman, as always, and that was part 2 of my conversation with Alex Walker, the current Rappaport Fellow at Harvard Law School and a lecturer on law. I cannot thank him enough for coming on this podcast, for being such an amazing interviewee, and for caring about whether or not I learned anything from him throughout this experience. I learned a tremendous amount from everyone that comes on this podcast, to be clear, but I think that Alex has definitely shown me what it is to invest in a student's learning outcome, and I'm very much inspired by that. You can read about him, optimality theory, his papers, etc. That's all linked in the episode description, or just in general, the internet. Recommend it. Go ahead and rate this podcast on Spotify, give me a review on Apple Podcasts, rate me on all the platforms and do all the things, and stream me on all those platforms and do all the things. And then, while you're at it, pass along the podcast to the masses, because if you are a fan of Tomato, chances are someone else will be too. And if you're not a fan of Tomato Tomato, then I think there's probably an even greater chance that someone else actually will be a fan of Tomato Tomato. Because maybe there's diversity of opinion in this world. I should hope. And with that, I will speak to you next time. Bye!